Most Americans think the Supreme Court changes the country by answering the biggest question in front of it. This time, it did something even more disruptive. Instead of settling the headline issue everyone was screaming about, the court struck at the machinery underneath the fight itself. And that is why so many lawyers, state officials, policy groups, and federal agencies reacted the way they did. Because when you change the rules for how a law gets stopped, challenged, or frozen across the country, you are not just changing one case. You are changing the way power moves through the American legal system. That is the update nobody can afford to misunderstand. Because the viral headlines make this sound like one more partisan war story, one more left versus right clash, one more political food fight that will disappear in 2 days. It is not. What happened at the end of June sent a shockwave through immigration cases, election fights, state-federal disputes, environmental rules, executive orders, and just about every major policy battle where one side used a single federal judge to block something nationwide before the courts had fully sorted it out. And here is what most people still do not realize. The real explosion was not the headline policy. The real explosion was the court telling lower judges that they may have been going far beyond the legal authority Congress actually gave them. In the court's own ruling, universal injunctions likely exceed the equitable authority federal courts possess, and the justices limited the lower court orders to what was necessary to give relief to the actual plaintiffs who had standing. The court did not resolve the underlying birthright citizenship question in that decision. Before we go further, if you want legal and political stories broken down in plain English without the spin, subscribe right now. Because this is exactly the kind of ruling that gets flattened into slogans by cable news, while the real consequences quietly spread through the system. Now, let's talk about why this hit the legal world like a blast wave. For years, nationwide injunctions became one of the most powerful weapons in American litigation. If a president issued an executive order, if an agency rolled out a rule, or if a state passed a controversial law, opponents could rush into federal court, find a sympathetic venue, and ask one judge to stop that policy for the entire country. Not just for the people who sued, not just for the state in the case, for everyone. Think about how extraordinary that is. One district judge, one courtroom, one lawsuit, and suddenly a nationwide policy could be put on ice from coast to coast before the full merits were resolved. That practice grew so normal that many Americans stopped noticing how strange it was. But late in June, the Supreme Court made clear that this kind of universal relief has weak historical grounding and likely falls outside the traditional limits of equitable power. According to the court, lower courts should not be issuing remedies broader than necessary to provide complete relief to the actual parties before them. That sounds technical, but that is only the surface. Because once you restrict nationwide injunctions, you create a very different legal reality. Instead of one judge freezing a policy for everyone, relief may now be narrower, limited, and tied to specific plaintiffs, class actions, or carefully defined parties. That means a federal policy might be blocked for some people while still operating against others. It means one state may feel protected while another remains exposed. It means the legal map can become fractured, while lower courts struggle to figure out where the new limits actually sit. Skoda's blog noted that the ruling could force far greater reliance on class actions and leave significant uncertainty around issues like third-party standing and broader relief. And this is where the chaos begins. Because supporters of the ruling say this is the court finally restoring constitutional order. Their view is simple. Judges are supposed to resolve cases, not govern the entire nation from one district courtroom. If a plaintiff is injured, the court protects that plaintiff. If millions of people want a broader answer, then the system should move through full litigation, class actions, appellate review, or Congress itself. Critics, however, see something far more dangerous. They argue that when courts cannot fully stop a potentially unlawful policy nationwide, people who are not already parties to a lawsuit may remain exposed while years of litigation grind forward. That was one of the central concerns raised in the dissent and in the immediate commentary that followed. Constitutional protections may become uneven in practice if broad relief is harder to obtain. So, no matter which side someone is on politically, the reason this ruling caused panic is obvious. It moved the system out of the old shortcut model. For years, when policymakers lost in Congress or faced resistance elsewhere, the courthouse became a national stop button. Now, the Supreme Court is signaling that the stop button may not work the way everyone assumed. That means advocacy groups must rethink strategy. State attorneys general must rethink strategy. Federal agencies must rethink strategy. And ordinary Americans may now live under a patchwork of enforcement, while the next battles climb back up the judicial ladder. The reality is even more significant than that, because the court did not answer every question. It left major issues open. It did not decide the underlying constitutionality of the executive order at the center of the case. It did not settle whether the Administrative Procedure Act might still authorize broader forms of relief in some circumstances. It did not fully resolve whether state plaintiffs can assert claims on behalf of their residents in the way some of these cases attempt. It also left the lower courts to decide whether narrower injunctions or other procedural tools should be used on remand. That means this was not the end of a legal war. It was the beginning of a new phase of one, and that is why so many people described the aftermath as chaos. Not because the court waved a magic wand and settled everything, but because it unsettled the procedures everyone had grown dependent on. It took a tool that both parties had used for years and suddenly put it under constitutional suspicion. That kind of shift does not create calm. It creates scrambling. It creates emergency strategy meetings. It creates new filings. It creates a race to class certification. It creates fights over who has standing, who is protected, who is not, and whether the lower courts will quietly try to rebuild broad relief under new labels. And here is what makes this story even bigger. This is not just about one administration, one president, or one ideology. The truth is, both sides have loved nationwide injunctions when they worked in their favor and hated them when they didn't. That is why this ruling hit Washington so hard. It did not just wound one camp. It threatened a habit the entire political legal class had learned to exploit. One sympathetic judge in one strategic venue could alter national policy overnight. That habit is now under direct attack. So what happens next? The next stage is not television drama. It is procedural warfare. Lower courts will now have to decide what narrower relief looks like. Litigants will push for broader class actions. States will test new arguments. Federal lawyers will test new defenses. Advocacy groups will shop for new procedural paths around the limits the court just emphasized. And because the justices themselves left important questions unresolved, future cases are almost guaranteed. In other words, the court did not lower the temperature. It moved the fire. That is why this ruling matters to ordinary Americans, even if they never read a single court opinion in their lives. Because when procedure changes, power changes. And when power changes, the effects show up everywhere else, in how fast policies can be stopped, how long they stay in force, and whether the legal protections people assume are secure actually apply to them in real time. That is the part most headlines never explain. They tell you who won the day. They do not tell you that the battlefield itself just changed. And once the battlefield changes, the people who still think they are fighting under the old rules are the ones who get blindsided first. So here is the bottom line. The late June Supreme Court ruling was explosive not because it resolved every major constitutional fight in America, but because it challenged the legal mechanism that had become one of the most powerful tools for freezing national policy from a single courtroom. The court limited universal injunctions, refused in that ruling to decide the underlying citizenship issue, and left lower courts and future litigants to fight over the consequences. That is exactly why the aftermath feels so unstable. If this helped you actually understand what changed, share it with someone who keeps seeing the headlines but still doesn't know what the court really did. Because this story is not going away. It is just getting started. I'll see you in the next one.